We will go ahead and get started today. I am Lauren Ward, and I'm an attorney with a business law firm. And today we're just going to go over some basic wills and trusts, kind of what is estate planning and what are the documents you may need. So I am recording this. It will be on my YouTube channel, so feel free to watch it later. I'll post it on LinkedIn as well, or share with anybody you think needs this information. Once again, I'm Lauren Ward, and I'm an attorney with a business law firm here in Spartanburg, South Carolina. We have a few more people joining us, so once they get joined, we'll just get everything started. So once again, I'm Lauren Ward, and I'm an attorney with a business law firm here in Spartanburg, South Carolina. I practice in the areas of estate planning, and so today is just going to be a very basic seminar on estate planning and kind of wills and trusts and what documents you need with estate planning. So we will go ahead and get started. It is being recorded, and if you have questions, feel free to send me a question in the chat so I can answer it for you as we go along, but we will get started. So what is estate planning? So estate planning is using various documents and techniques to decide how your assets will be distributed when you are no longer here, plus creating documents for directives for your life. So there's two types of kind of estate planning, kind of life planning as we call it. There's like your estate documents for when you're no longer here, and the documents you need during your lifetime, like powers of attorney and those type things.
As long as you have a different address, because you have to live in the home to get the repairs.
It's unlivable.
I understand that, but
so at this point, a little bit about me. If this is your first time joining my seminar, I'm a graduate of the University of South Carolina, also graduate of the University of South Carolina School of Law, and my practice areas are estate planning, business planning, and Medicaid planning, just so you know a little more about me. So today, we're going to talk about what is a will and what is a trust, which one is right for me, how do I fund my trust. So in South Carolina, if you don't have a will, one has been established for you through the South Carolina Probate Code under the laws of intestacy. And sometimes this creates unwanted results. You may not want your estate governed by intestacy. For instance, if you are married and have children and you pass away, the laws of intestacy would give half to your spouse, half to your children. You may not want it all to go that way. You may want all of it to go to your spouse, and only if the second spouse passed does it go to your children. So it can create some unwanted consequences when you don't have a will, because the state's pretty much made one for you. So I think when should you have a will is always a big question. I think when you have any assets like cars, bank accounts, anything like that, you have assets, you need a will. Definitely if you own land, you want to have a will in place. And one time people forget is maybe I don't have anything much, but I have children. Well, we want to have a will in place for those children because we want to make sure we put guardians in place if something happens to you. So those are the big times you need a will. I think when it is a necessity, if you have children, I think you really need to have that will to have the guardian in place. I think if you have children with a previous marriage, you want to make sure that's handled the way you want it. I think if you have individuals with disabilities you're leaving something into, you want to have a will to make sure it doesn't hurt their Medicaid or SSI. And also times when you have no children, no spouse, maybe you want your assets to only go to one family member, or you want them to go to a charity or something like that. Those are times you really need to have that will. It's times we don't think about it as much, but definitely important. So like we talked about before, if you don't have a will and you die under South Carolina Probate Code, the spouse receives half of the estate and the children receive half of the estate. And if they are minor children, this may involve conservatorships. And those are things that can be costly, expensive, where if you had a will and you just wanted to leave it all to your spouse, you could do that and it would avoid this. Or if you're going to leave some to your children, we could have it held in some type of trust or guardianship account for them while they're minors and not have to do a conservatorship. A conservatorship requires a true court action in probate court where you have to go in front of the probate judge and do things like credit checks, sled checks. even if the child is yours, even if you're the biological or guardian or whatever, you still have to go through this procedure. So it's definitely important to have that will in place. So something people don't realize also in South Carolina is we have what is known as the elective share. What the elective share means is that you have to give your spouse a third of your estate. If you don't, they can claim the elective share and get a third of your estate. So sometimes there's ways we can work around it and maybe only give them income from a trust and different types of things. But this definitely something, if you're wanting to leave your spouse out, making sure you do it properly with the elective share being in place so there's no issues. If you don't want to leave your spouse anything, you need to have a prenup before you get married, or you can do what's known as a postnup after you get married. But I will say the courts are very strict on these. So you really want to have that prenup or postnup properly done to make sure it's upheld. We did mention family members with special needs who are differently abled. Maybe they're receiving Medicaid or SSI. You want to make sure you leave it in some type of third-party supplemental needs trust so they don't lose their Medicaid. And when you do it as a third-party supplemental needs trust, we don't have that Medicaid payback provision. So if you do have family members you're wanting to leave assets to who do get SSI or Medicaid, it's really important to have a plan in place for them so they don't lose those benefits. And I don't like the thought process, oh, I'll leave it all to my one child and they'll take care of this child, because that puts a burden on that child. And you don't know what financial situation they're going to be in and if they're actually going to follow through with it as much as you trust your family. So I like having actually spelled out, laid out for them in person. So that way, you know what they know what you want and the expectations are clear. And we have this individual with this differently abled, we have them protected and everything. So that's really important if you have special needs members in your family or friends that you're wanting to leave assets to. So a lot of times people ask me about a trust and what if you need a trust, if you don't need a trust, those type things. It is really personal preference for the most part if you want to have a trust or not. Sometimes it's more beneficial than others, but a trust is pretty much a contract between you as the trustee and you as the beneficiary and you as the settlor on how your assets are going to be distributed after your death. It is a legal entity. While you're living, it's usually a revocable trust. It doesn't need its own tax ID number. It's really no different than you. But it can hold property. It can hold tangible property like real estate, and it can even hold intangible stuff like stocks and those type things. The trustee always holds the legal title of the property for the benefit of the trust, and the trustee operates for the benefit of the named beneficiary. So a trust is a vehicle to avoid probate in all reality, but it's just really a contract on how these assets are to be held for the most part with estate planning. Some big advantages of a trust is it provides financial protection and asset protection. So that way it avoids probate. It keeps your assets all in one place. You can put provisions in it to protect minor children. So it's held in trust for them till they're like 25 years old. You can do the special needs planning as part of your trust, and that way you can have that third-party trust incorporated into it for your children or family members that have those special needs. And we can always put a contingent one in there if you don't have anybody now, but there's always the possibility that could happen. Sometimes trusts can be used for Medicaid and asset protection planning. Those are a little more different, and they have some different terms in them and stuff, and typically they're irrevocable, so they are a little different. You also can use trust to help, like if you have children who have creditors and aren't good with money, you can have it held in trust for them. If you're worried about one of your children getting divorced and you don't want your assets to go to their ex-spouse, that's a way to protect too, using these trusts. So they do have some advantages, just more than protecting it from going through probate. They do have different advantages. It is a personal preference, though. I don't think there's either 100% right way to do it. It's your personal preference and weighing the pros and cons. Typically, I tell trusts are more, sometimes they're needed just because you've had a bad probate experience and you just want to have it avoid probate. Sometimes they're wanted because you have that, you want privacy. Probate is public record. A trust is not. So you get that privacy with it. I think the big times people really need to look into trust are if you own land in multiple counties or states, because you're going to have to probate everywhere you own that land. So if you own land here in Spartanburg and maybe you have a beach house down in Beaufort, you would have to probate here in Spartanburg and Beaufort. Or if you have one here in South Carolina and you own something, maybe you have a nice mountain house up in Cashiers, North Carolina, you'd have to probate in North Carolina too. It's also a good idea at homes for business owners to have that trust so the business can avoid probate and helps it continue running smoothly. If you need those spendthrift provisions, so you have a child that is just not good with money, is going to spend it all, has a lot of creditors, and you want that protection. You have those minor children. You have disabled family members. You're thinking about that Medicaid or asset protection. And sometimes you just want it easier on your family. You don't want to have to go through probate. You don't want stuff to be struggled through all of that. You just want to be able to transfer over to them right at your death. You just want it easier and you want privacy. And that's always a good reason, just a personal reason you want to have a trust, and that is completely fine. Trusts don't have to be these $2 million, $3 million assets. You can have a trust just for your house, just so it avoids probate to make it easier for your family. So there's different types of trusts. We have the revocable, which is what most people use just for basic estate planning. We have irrevocable trust, and that's more used in the special needs area and the Medicaid planning area. And sometimes we have pour over trusts that are created through your will and those type things. When we look at funding a trust, we can put all different types of things in there. We can look at putting our bank accounts in there. You would just go to the bank and change the name of them to put in the trust. We could put our real estate in there, but you have to use a deed to do that. We could think about putting automobiles in there, but that's something you really want to weigh the pros and cons are because of insurance laws and those type things. That's not an always do it situation. You can put your personal property, that's all your household items, those type things. You can put mutual funds in the trust. You can have them either held in the name of the trust, or you can have them at your death go to the trust. Same with insurance policies. They can be payable on death to the trust. You can also make a trust the beneficiary of a retirement account. That's one area you really have to weigh the pros and cons on because of their tax implications with retirement accounts, like those qualified accounts where you haven't paid taxes on them yet. We really have to weigh the pros and cons on how you want to fund your trust with retirement accounts. If you have minor children, probably definitely worth it. Special needs families, definitely worth it. But if it's something like you're giving it to your minor children to be held, you're giving it to your adult children and it's not going to be held in trust form, you may just leave them as the beneficiary on that account. So that's one thing we just would have to look at the pros and cons for and talk about on an individual basis. A lot of times I get the question, so I have a trust, do I still need a will? The answer is yes. You want to have a very simple pour over will that says, if I die, all my assets funnel into my trust at my death. So that way there's no issues with it. It all just goes into your trust at your death. So that way you don't have to worry about it. It's all taken care of. And it just goes into the trust at your death, but it will still go through probate. So you want to fund your trust as much as possible. But that pour over will is just a catch-all. Maybe there's this bank account you forgot about or something like that. It would then funnel it into the trust. So that's pretty much the basics of just estate planning with wills and trusts. Very simple level of things, just kind of telling you what a will is, what a trust is. There's other documents I recommend having during your lifetime. This is more of your life planning, not your estate planning, but a general power of attorney for financial reasons, because if you become incapacitated, somebody's going to have to keep paying your bills, handling your finances. And if you don't have a power of attorney in place, what this means is they're going to have to go through the court and get a conservatorship appointed. And that is costly. That is not a fun process for anybody. I'm happy to do those for clients, but it's not an easy process. A doctor has to declare you incapacitated. And it's a true legal process. And with that conservator, somebody has to get a bond usually. So it's a little bit definitely harder than just having that power of attorney in place and set up for your family. And then also having that healthcare power of attorney where you name somebody to make medical decisions for you if you can't make those for yourself. And inside of our healthcare power of attorney In today's time, we have that living will. So that way you can make decisions on those hard things like life support, feeding tubes, and organ donation. So I know those aren't fun things to think about, but I definitely think those powers of attorney for financial and for medical are definitely needed by everyone, whether you're 18 or 100. Those are documents that we really need to have in place for everybody. And I think really the question, I think everybody needs at least a basic will in place. And then the question between a will and a trust is just your personal preferences, your situation, and what you want to do. And weighing the pros and cons. And that's usually what we talk about in like an initial consultation with somebody, is to kind of see what their situation is, what their assets are. So I can recommend what I think is best too. But at the end of the day, it's your ultimate decision on if you want to have a will or a trust, or how you set up that estate plan. And at the end of the day, it's your decision too, how you want to give those assets to whoever. The only requirement we have in South Carolina is that elective share requirement. And just so you know, the capacity to make a will is you have to know what your assets are and who you want to give them to. So it's pretty low bar for capacity to do a will, but I always recommend people do it while they're younger and they make sure this is what they want to do, because none of us know what tomorrow holds, and you keep putting it off, and then maybe you don't have capacity to do it one day. So I think it's important to get these documents in place while you have mental capacity to do so, and you know what you want to happen, and having those powers of attorney are really important too. But that is it for our webinar today. Just wanted kind of a overview of the estate planning. I know I've done this one before, so I just want to touch on it again, and we'll go more in depth with wills and trusts and probate and estates in future webinars. But once again, I'm Lauren Ward, and I'm an attorney with a business law firm here in Spartanburg, South Carolina. My phone number is on the screen, as well as my email address if you want to reach out to me about any of this. Also, if anybody has any questions right now, I'd be happy to answer any. I'm not seeing any questions, but if you do have those that you don't want to ask in front of other people, feel free to send me an email, give me a call. But I hope this was helpful and informative, and we'll have some more webinars coming up in the future, and we hope you will join us for those. And feel free to share this with any of your family or friends. I hope you all have a great day.